I just saw my very first I-130 denied without an opportunity to provide more evidence, without a request for evidence, without a notice of intent to deny, without a second Stokes interview, with really no opportunity to remedy the situation. This wasn't a client that I had represented, but I consulted with him after the I-130 and the adjustment of status that was filed with it were denied. And I was trying to explain what his options are moving forward. So I thought I would make a video on this subject because as I was explaining it to him, I realized he might be in big trouble. So this guy had filed an I-130 concurrently with an I-485 application. And when he went to his adjustment of status interview, the officer just asked like 5 or 10 questions, didn't ask for more evidence, didn't really even give him a good opportunity to respond. And then the officer ended the interview. A few weeks later, they received an I-130 denial notice, and then about a month after that, an I-485 denial notice. And the problem here is that an I-485 denial under current immigration policies is going to automatically trigger a notice to appear if you're otherwise out of status. And by the way, in some instances, I've even seen it trigger a notice to appear in error when you are otherwise in a lawful status, like an H-1B status or some dual intent visa. So the question becomes, what do you do if this happens? Well, the case is going to go before an immigration court, and you can no longer file your I-130 and I-485 concurrently once you're in removal proceedings. And sure, he could have filed these new applications concurrently before the notice to appear was generated, but that's not going to necessarily prevent the notice to appear from being issued. And the moment it's issued, the USCIS will administratively close the I-485 application and claim that they no longer have jurisdiction over it because their records indicate that you are in removal proceedings. You can have it reopened if you terminate removal proceedings, but that's actually a pain as well. And my previous attempts to reopen administratively closed I-485 applications, and even in some instances N-400 applications for naturalization after clients were placed into removal proceedings, and then I fixed it and terminated the removal proceedings. Those attempts were usually unsuccessful, and we waited like a year after making multiple attempts to reopen, and then ultimately decided this isn't worth the time. Let's just spend the money and refile these applications so that USCIS can make a decision on them. And one of the problems here is if you refile the I-130 and I-485, you're going to waste another $1,440 on average on the I-485, and only for USCIS to administratively close it and say they're not going to make a decision on that. So what happens when you're in removal proceedings? You can only file the I-130 because the immigration judge will never have jurisdiction over the I-130. You have to file a standalone I-130 just with USCIS. And when that gets approved, you show the immigration judge that the I-130 is approved and ask the immigration judge to terminate removal proceedings so that you could refile a new I-485 with USCIS. That's generally the procedure for everyone except for arriving aliens and a few very rare exceptions. But like 99% of people are going to have to do it this way. There's a big problem with this strategy right now, and it depends on the timing and interplay between the timing of USCIS and the immigration court. Immigration judges are not really allowed to extend your removal proceedings anymore under recent policies. So when you show up to your first removal hearing, the judge is going to say, what defense from removal will you be seeking here? And my response will be, well, Judge, my client has an I-130 pending from a U.S. citizen spouse. And once that gets approved, we're going to apply for adjustment of status before you, the immigration court, or more likely, we're going to request termination of the removal proceedings so that we could file the I-485 with USCIS. If you're in removal proceedings, the only person who has jurisdiction over the I-485 is the judge, but only after USCIS approves the I-130. If you're not in removal proceedings, if you're able to terminate the removal proceedings, jurisdiction goes back to USCIS, and then you could properly refile the I-485 with USCIS in that scenario. The biggest problem with this strategy under current policies is if the immigration judge has a final trial date available that's gonna come sooner than your I-130 gets approved, the judge might say, You need to show me what defense from deportation your client qualifies for right now. He doesn't qualify for adjustment of status because he doesn't have an approved I-130, and I can't just give you a year and a half for your I-130 to get approved, which is ballpark current processing times when you file a standalone I-130. When you file it concurrently with the I-485, it's super fast, like 4 to 6 months in most parts of the United States. But a standalone is gonna be like 18 months. So if you're in some parts of the United States where immigration court proceedings are fast, like less than 18 months from start to finish, you might not have enough time to get an approved I-130, and then you really risk being forced to apply for another defense from deportation, which oftentimes for many people is just an asylum application. And if you've been following my channel, you know that asylum is pretty much dead. Not totally dead. You can still get asylum granted, but the pathways to be granted asylum have been severely limited in the last year. Let me give you a real life example of how this could play out. If you have removal proceedings in New York City, there's a decent chance, depending on which judge you get, there are like hundreds of judges now. They just hired 77 new Trump appointed judges in March of 2026. And they've been firing all the good immigration judges in the immigration court that grant relief to immigrants, although some of them still remain, so that's not a blanket statement. But in most of New York City now, from start to finish, your removal proceedings are going to take less than 18 months. If that I-130 petition is not approved before your final trial date, you are at a much higher risk of being ordered deported, even though you totally qualify for adjustment of status. And that is an intentional policy that's designed to reduce the flow of legal immigration right now. But conversely, if your removal proceedings are, for example, in Newark, New Jersey, removal proceedings there can take 3 to 5 years. So you likely would have enough time to get an I-130 approved with USCIS, file a motion to terminate with the immigration judge because you're probably not even close to your final trial date yet, show the judge you now qualify for this alternate form of relief, adjustment of status, and then ask the judge to terminate so that you could file a new I-485 directly with USCIS. This is the very first time I've really seen an I-130 petition get denied somewhat summarily without a request for evidence, notice of intent to deny, second interview, which is often called a Stokes interview, or any other way to remedy the situation. USCIS officers have had the power to do this for over a year now. There was a policy memo that was issued pretty soon after Trump took office, indicating that USCIS officers are no longer required to issue a request for evidence. But in practice, they usually do. And this is the first time I've actually seen something like this happen in my practice. One of the main points I want to get across in this video is that you need to ensure that your I-130 evidence is as strong as it can possibly be before you show up to the interview. If you didn't submit good evidence along with your I-130, right before your interview, you should be logging in, or your attorney, or if you guys hire my office, we will be logging in for you and uploading more evidence to your I-130 portal to ensure that your interview goes as smoothly as possible. In all fairness, this guy's evidence was somewhat lacking. So the USCIS officer actually didn't do anything procedurally incorrect. I mean, he could have been nicer about it. They didn't have to do it this way. Most USCIS officers would have given the applicant or beneficiary in this situation an opportunity to supplement with more evidence, or at least ask them if they brought more evidence to the interview, which this guy did do, but the officer never asked him about it, and he was really nervous and he never submitted it. So, there were problems all around with this case, but it is a warning. If your I-130 gets denied, it's not guaranteed that you're going to be able to adjust status even in removal proceedings. All right, guys, so this brings us to the end of today's video. If you got anything out of this or anything out of the videos I put out, nothing would help me more than for you to like the video or leave a comment telling me what topics you want me to discuss in future videos. A lot of the topics that I'm going to be putting out this week came from the comments that people posted in the last week, giving me ideas for new video topics, and I really do appreciate that. I want to spend my time creating content that helps you guys out along your immigration journey. If you need any assistance with any immigration matter, my name is Pouyan Darian. I'm an immigration attorney handling these cases nationwide. We focus on family-based immigration. My favorite cases are marriage-based adjustment of status. We also do a ton of naturalization cases, removal of conditions, whether you're in a good faith marriage or divorced, and removal defense, unfortunately. If you need any assistance, the first step would be to schedule a consultation by clicking the link in the video description below, and I'll see you guys next time for another video.